Today I'm going to talk about the Interstate Commerce Clause. It is a relatively important legal matter, but it's really easy to overlook, so I want to make sure that we understand it clearly. First, let's talk about what interstate means. Interstate means between or among the states, something that doesn't happen simply within inside of a state, but goes across state lines. In contrast, intrastate deals with something that's wholly within one state. The Interstate Commerce Clause is actually about the Constitution. It's about the powers that the federal government has and the powers that the federal government doesn't have. When the guys got together to write the Constitution, there was a lot of debating. One of the big debates was about the role of the federal government as opposed to the role of the state governments. Some folks wanted a very strong federal government, with states playing a small and minor role, but other people wanted for each state to do whatever it wanted, whenever it wanted. As is usually the case, the result was a compromise. The Constitution created the federal government and created the three branches of government. It anticipated that the laws would be drafted by Congress, and so it limited the powers of Congress. There were two ways that they could limit the power of Congress, and one was to say, you can do whatever you want except, and then list all the things that they didn't want Congress to get involved in. The other way was to tell Congress that it couldn't do anything except, and then list the stuff that Congress could do. The Constitution follows this second path. It says that Congress can't do anything except, and then it lists the stuff that Congress could do. The list is found in Article 1, Section 18 of the Constitution. We've gone back and numbered the things that Congress can do in Section 18, and since we've numbered them, we've decided to call this list the Enumeration Clause. One of the major powers that was given to Congress was the power to legislate commerce amongst the various states. That means interstate commerce. In our trade, we're going to call this provision the Commerce Clause. For years, this provision was construed to mean that Congress could validly legislate only on matters that directly affected interstate commerce. For example, if a large coal mine in Pennsylvania supplied coal to the entire eastern seaboard, the courts would agree that the coal mine was subject to federal control under the Commerce Clause. Let's go back in time. About 75 years ago, the scope of the Commerce Clause was significantly expanded. So we're going to go back in time to 1938. The country was starting to come out of the Great Depression. Congress was worried that we might start to produce too much wheat, which would drive the price of wheat so low that it would destabilize the delicate economy that had emerged. So Congress passed a law called the Agricultural Adjustment Act, which limited the amount of wheat a farmer could grow. In 1941, Roscoe Filburn grew too much wheat. He was violating this new act, and the federal government assessed him with a fine. Filburn refused to pay the fine. He argued that he was going to use virtually all of the wheat on his own farm, to feed his family and farmhands, and to feed his chickens. He said that if he did have any excess wheat, it was going to be sold at a local market, to local people, and that none of his wheat would cross state lines. He reasoned that since he didn't or wouldn't ship his wheat across state lines, then the federal government didn't have the right to regulate how much wheat he grew. And the trial court agreed with him. But the case made its way to the United States Supreme Court and was decided there in 1942. The court ruled against Filburn. The court reasoned that if a lot of people did the same thing that Filburn did, it would affect interstate commerce. They were worried about the cumulative effect of people violating this law. If everybody in Ohio decided to grow wheat, then the folks in Ohio wouldn't buy wheat from farmers in other states, and that would affect interstate commerce because people in Pennsylvania would no longer be able to ship their wheat to people in Ohio. Ever since then, courts have said that Congress can regulate commerce anytime the cumulative effects of that commerce might affect interstate commerce, even if what they are regulating is wholly intrastate. Imagine a baker in Seattle who bakes and sells cakes. All of the people that he sells to live in Seattle. None of his cakes ever cross state lines. Is he involved in interstate commerce? Sure he is. He buys flour and sugar, much of which was likely shipped to him across state lines. If he stopped making cakes, the people who used to buy his cakes might go buy their cakes from Walmart, which has cakes shipped from across the country. So even though this baker is not personally involved in interstate commerce, what he does affects interstate commerce, and he is therefore subject to federal regulation. Whenever you have a case that involves the question of whether interstate commerce is involved, don't simply look at the state and ask whether the person is doing business only in this state, in intrastate commerce, but instead ask the question of whether what he is doing has an effect on interstate commerce. If it does, then he's involved in interstate commerce. Remember, the question is never whether the particular person who is subject to regulation is involved in interstate commerce, but whether what that person does, together with other people like him, have a cumulative effect on interstate commerce.